So let's just talk about information versus evidence. Example, Judge, I spoke to so-and-so over at the bank and they told me that I had nothing to worry about, and the next thing I knew, I had the sheriff knocking on my door. That's information. It's not evidence. Why not? It's not evidence unless you are in an evidentiary hearing that's been properly noticed and you are sworn by an oath to tell the truth, and the judge accepts your testimony and you are subject to cross-examination by the other side. Keep in mind that these are the rights of the other side, but they're also the rights of your side. Our rules of evidence and civil procedure are supposed to act, you've heard the term blind justice. They're supposed to act the same for both parties. So if you raise an issue of fact, say by having the declaration of an expert who says that the creditor is not present in court and that you're under an obligation to try to modify or settle with the creditor under the federal law or under a state law or whatever, then you're in a position where you're raising an issue of fact. Remember that if you give an affidavit, or if the other side gives an affidavit, that is not evidence. It'll become the equivalent of evidence if you don't object. And believe me, any affidavit that you submit, the other side will object. An affidavit is not the same as evidence. A declaration of an expert is not the same as evidence. But what it does do is it raises an issue of fact. The expert presumably will say that the other party in this case, or the other parties, many times there's more than one, are not creditors. The attorney will have represented that they are creditors. The attorney for the lenders or pretender lenders or services or MERS or whoever it is. All you need in that case is to have an issue of fact, which means you've got something that there is a dispute over. They say they're creditors. You've got a witness that says they're not. You're entitled, therefore, to make inquiry of them, and they are entitled to make inquiry of you and your witness. And that's exactly what you want. Because as soon as you get into the discovery stage, and as soon as you get the attention of the court directed away from legal argument, philosophical differences, ideological differences, and directed at things that judges are used to ruling on, which is whether or not you're entitled to an answer to an interrogatory, whether or not you're entitled to the production of a document. This is about the discovery of evidence. And it's about anything which might lead to evidence which could be admissible in court. So you have wider latitude in discovery than you do in the courtroom. The main point that I want to make here is that you need to be aware of the fact that just because you say something in court doesn't mean it's a fact, doesn't mean that it's accepted, and it certainly doesn't mean that it's evidence. And the contrary is also true. Just because a lawyer with a $1,000 suit walks into court and makes representations to the judge doesn't mean that it's true, doesn't mean that it's a fact, doesn't mean that it's evidence, and doesn't have to be taken as true. All you need to do is object and say, I want to see what? The evidence.